Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to Season 7, Episode 3 of Fire Away. Today, I'm very excited to be joined by someone who's usually behind the scenes on Fire Away, Mark Robbins, who is one of our executive producers. Mark is also the CEO of LawyerLocate.ca, LegalTube, and Digital M Space, who are valued partners of Rudner Law. Mark has many years of experience as a business owner and employer in Canada. And I'm very excited to have you on the show, Mark, so that you can essentially be the face and the voice of the business owner in Canada and ask some of the questions that we've received over the last few months. So thanks for agreeing to come out in front of the camera today.
Oh, thanks, Stuart. I really appreciate it. It's fun. It's different being on this side of the camera instead of behind the scenes where I just get to watch and critique. But again, thank you so much for inviting me.
It's going to be a lot of fun. I didn't say it in the intro, but I'll say it now. In addition to everything else I said about you, I consider you to be a friend, as well as someone whose opinion I value in every aspect except for hockey, of course. We'll get to that at some point. But I think you're the perfect person to do what we want to do today, which is talk about some of the questions that we receive and the questions that the frequently asked questions that come up from the employer, business owner perspective, and try to address some of those myths and misconceptions that we're constantly trying to deal with. So let's get right into it. I'll let you lead from here.
Yeah, terrific. So what we're going to do is we're going to pull some questions that we've received over the many months, or actually years, that I think are relevant to today's time frame. So I'm going to ask Rob, our producer, to put up our first question. We'll go from there. Why do all the recent headlines seem to say that termination clauses are no longer enforceable?
Yeah, this is a great question, and I'll give a little bit of a background by saying that I've been practicing employment law for 25 years now, and courts are constantly grappling with the idea that they need to protect the rights of the individual, i.e. the employee, as well as the corporation, i.e. the employer. And over time, anybody in the employment law world will say that it's like a pendulum, and it goes back and forth and back and forth. But what's interesting is for most of those 25 years, it's sort of been between here and here. And now it's here on the employee side. For whatever reason, in the last 4 or 5 years, we've seen a number of court decisions, primarily in Ontario, but also in other provinces, that have tried to find ways to protect employees, and specifically to find ways to invalidate termination clauses. And the reason this is important is because, and I could spend half an hour to explain this, but I will not do that. Termination clauses generally are designed with two purposes. One is to provide some certainty as to how much someone is entitled to if they are let go without cause, how much severance they get. So it's to provide certainty, but it's also, from an employer perspective, to reduce the amount of severance the employee will get. And to give you a somewhat extreme example, in some cases, it could be the difference between 24 months of severance and 8 weeks of severance. So it's a massive hit to an employee. And as a result, courts are often trying to find ways to get the employee out of the consequences of the contract they signed. And what we've seen in the last couple of years is courts taking very creative ways to do that frankly, I don't think anybody in the employment law bar would have expected. And the end result of that is that the vast majority of clauses that I see are not enforceable. But a lot of, I'll say most employers think they have contracts that are enforceable, and they don't realize how much liability they might have.
That's interesting, Stuart, because just briefly, we, as an employer, as you pointed out myself, we had an issue some years ago in Ontario with one of our longstanding employees, and it was just prior to COVID, and we were getting ready to we had already announced that we were going to be moving our offices to Alberta, and that we negotiated with the employees to be working remotely. They'd all agreed to that. And then in that kind of 2.5 month, 3 month window, COVID came, and this one particular employee just ended up he fell off the end of the rails. It became a really not a good employee, and we terminated him with cause. And it just became a major poop show, for lack of better terms. We didn't end up in court. We did end up with the labor board getting involved, and I would say not negotiating, but I guess ordering after they had heard both sides of the story. That we had to pony up what I thought was an excessive amount of money for an employee that had breached a lot of his responsibilities. So going back to one of the things I know that we talk or you talk about a lot, and it's also part of the closure show. It's like if you think you need an employment lawyer, you probably do. And in that case, in hindsight, which is always 2020, we're always Monday morning quarterbacks. I too was victim of not being smart enough to say I was being penny wise and pound foolish, and I think that happens a lot. With that, Rob, let's see what the audience wants to ask Stuart now.
Perfect. And just before you get to that one, I have to say that's a great example, but it's also really telling because you work with lawyers all the time.
Yeah.
And if anybody should know that you should get legal advice proactively, it's you. And yet you chose not to in that case. And I will admit, many years ago, when we were looking for office space for my firm, and we put an offer in on some space, and then we got the lease. And I actually had that moment of thinking, well, should I get a real estate lawyer to look at this?
Right.
And I had to step back and say, what would I tell myself if I was a client? I'd say you're stupid if you don't. But I was prepared to go ahead without that advice. And this is the common issue that we deal with, where most people make that decision and it seems perfectly rational at the time. And as I have often said as well, it almost always costs you more to fix the problem than it does to prevent it. So you end up spending more in the end, but penny wise and pound foolish was one of my grandmother's favorite expressions, and it's really apropos here.
Yeah, for sure. Absolutely. Go ahead, Rob, put the next question up. I have an administrative and sales staff that still work from home. Can I require that they return to the office? This is a very timely question.
Very timely, and I haven't said it yet, so I'll say the typical employment lawyer's answer now, it depends. So you got to take a step back. You got to remember, as the other thing that I always say, I guess there's a bunch of them now, is that employment relationships are legal relationships. They're governed by contract. So whenever a question like this comes up, look at what the contract says. So in this case, maybe the employee has a contract which says you will be working from the office. Or maybe they have a contract, maybe they're hired during COVID. So they've never physically been to the office. The contract says you're going to work from home or is silent on the topic. You've got to figure out what the contract says, either explicitly or based on past practice. So if the contract says you're going to work from home, then it's pretty much a no-brainer at this point. You don't have the right to insist they come into the office. That would be a material change, which would trigger a constructive dismissal claim. But let's assume that you're like most employers, where either there is no written contract or the contract is silent on the issue of where they're going to work, or the employee was always working in the office before COVID. Then, of course, March 2020 hit, everyone scrambled, they went home. But now it's April 2024. And you can't say that you're only doing this, you're only having them work from home because it's a necessity anymore. So have they essentially accrued the work from home over sometime over the last 4 years? And I think, and we don't have any case on this to be clear, but my view is that if you've allowed someone to continue working from home up until now, without ever communicating to them that you retain the right to bring them back, then they probably have accrued the right to stay at home now. And if you force them to come back, that would be a constructive dismissal. Smarter employers, and certainly the employers that we were advising through COVID and after, were very clear in their communications in saying, you're going to be working from home for now, but we have the right to bring you back to the office. If you haven't done that, then I would say that their contract is based upon the last couple of years, and they've essentially earned the right. So this is becoming a battleground that we're going to see a lot of case law come out of in the next couple of years.
Interesting. So let me follow this one up, and I'm going to bring this a little closer to home for you, because I know that there were substantial changes to how your practice physically changed over COVID. I understand you no longer have brick and mortar office. You use remote offices for meetings when that's required, but all of your staff work remotely from home. So my question is, What if a staff member says, I no longer want to work from home. I don't like it. It doesn't work for me. I want to come into an office a brick and mortar office that no longer exists. How do you handle that?
It's a great question, Mark, and it's certainly not the norm of what we're seeing, but it has come up in some context with our clients. So we have had to address this for clients as well, and it's the same analysis, just reverse all the terms, basically. What is their contractual entitlement, or what is your contractual obligation as an employer? So if they either were hired to work from home, then they're now seeking to make a change. So as an employer, you could agree to have them come back into an office or find an office for them if you don't have one, but you don't have to. However, if their contract was that they are to work, let's sort of rewind a couple of years. Let's assume that you had a company where everyone worked in the office. So now everyone's gone home for COVID. Now COVID is largely gone away, and it's possible to go back to the office, but the company says, you know what, we're just going to get rid of the office space and everyone works from home. And one employee says exactly what you said, Mark, I want to come back to the office. At that point, they may well have a constructive dismissal claim because their contract says they're going to be working from the office. You've now changed a fundamental term. So if that was the case, then we haven't seen that yet, but it's entirely possible. Now, the other thing to throw into the mix really quickly is condemnation. At some point, if they haven't complained, they'll essentially be deemed to have accepted the fact that they have to work from home. So they couldn't wait a year or two and then say, I want to go back to the office.
Okay. So we wanted to keep this timely and topical. So right now we're coming into the end of the NHL season. I'm a huge Leaf fan, as you know. I know you're an Edmonton Oilers fan. The Leafs, Austin Matthews is trying to get 70 goals with 2 games left in the season. So it's a long way around the rink to get to the question I want to pose to you. So I work for you. I'm a huge Leafs fan. You're an Oilers fan. We're both out of it. We're passionate, almost crossing the line to where it's obsessive. I post all kinds of stuff on my social media platforms about how much I don't like Edmonton. They're the worst team in the AHL. Connor McDavid's the most overrated hockey player that ever existed. Lottie, lottie, lottie. You're the employer. Do you have the right to terminate me for those social media posts that oppose your viewpoints?
So it's a great question. I think it's probably a question that, as they say in the movies, would be based on a true story, since I have seen your Facebook posts on Austin Matthews and the Edmonton Oilers. And we can certainly devolve into that debate at some point, but we'll save that for another show. But this is just another variation of a question that I've been answering for years now, which essentially comes down to, can you be disciplined or dismissed for your off-duty conduct? So I've been talking about that largely because of silly posts that people make online. And you start with the proposition that what you say or you do on your own time is your own business. That's the starting point. But the law for many, many decades, long before internet and social media, has provided that employers can impose discipline or dismissal in certain circumstances, typically where it impacts either the employer or the employment relationship or the reputation of the employer. So to take your scenario where you're posting all these things, negative things about the Edmonton Oilers, and I don't like it, as an employer, I've got a couple of options. When I said that you can discipline or dismiss someone for their off-duty conduct, I was talking about dismissal for cause. And as regular viewers will know, we've got 2 types of dismissals in Canada, with cause and without cause. So with cause means that that's what usually people mean when they say fired. You're being let go, fired with no severance, no notice, no nothing. And the threshold is extremely high. So in your scenario where you're posting silly things about hockey, that's probably not going to be just cause. So, however, let's change the scenario a bit. Let's assume that you're my employee and I am the general manager of the Edmonton Oilers Hockey Club. And you're online posting about how the Oilers suck and the Leafs are going to win the cup. All of a sudden, that might be just cause for dismissal. Or I'll take it one step removed. Maybe we both work for the advertising agency that works for the Edmonton Oilers, and you're posting about how bad they are. Again, that type of thing might give me just cause for dismissal. Otherwise, it won't. But I think it's important to remember that in Canada, most people don't have job security. So, with the exception of unionized employees and some federal employees, you can be let go at any time for almost any reason, as long as you're given your severance pay. So, I might decide that, you know what, I don't have just cause to fire you, but I can't, in good conscience, employ someone who is an avid fan of the Toronto Maple Leafs. So, I'm just going to let you go, but I'm going to have to pay you your severance.
Okay, and to follow up on that, let me ask you this, Stuart. If we get beyond kind of sports and we take it to a little more, I'm not going to specifically newsworthy, but if we get into, because it's an area to me that I'm very curious about as an employer, religion and politics and employment always have been something that concern me because you can have employees that have different religions that may be opposed to each other. You have different political viewpoints, and then that can also bleed into the employer, where you may have an employer who is very radical in their religious beliefs and are not tolerant of or having trouble being tolerant of employees who are of another religious belief or another political belief. So a similar scenario we just talked about with the two hockey team things. But I think this takes it up to another level because I think when you start bringing in religion and politics, it's got to be far more complicated. I know as an employer, I would have a real challenge as to saying, I wouldn't have a challenge keeping my religious beliefs separate from my work, but I know of people in my work experience that really are challenged by that. If I was anti-Semitic and my employer was anti-Arabic, that would be a problem. How would that play out as far as what the employer's responsibilities would be?
Yeah, look, I think it's a very timely question. I think, we're all, we want to try to avoid getting into the discussions of politics and religion and all that. But I think, first of all, I'll say this, which is not really a legal comment, but I really encourage everyone to embrace tolerance at this point as we see what's going on around the world. But your question, I mean, it's interesting because when you look at some of the political, religious issues that are ongoing right now, they're not all that dissimilar to the hockey discussion we just had when it comes down to how the law applies. So again, we're talking about, I mean, first of all, think about whether you should be dismissing someone because of their views. But if you are truly troubled by their views, or if you think their views are inappropriate, then you've got to assess, would it be just cause for dismissal? So again, is it somehow impacting the employment relationship, the reputation of the company, et cetera? So, if your organization is affiliated with something that relates to whatever issue is on the table, and one of your employees is posting something that is just directly contrary to everything your organization stands for, then it may well be just cause for dismissal. Otherwise, if your company or your organization has nothing to do with that issue, you have to assess, is it still impacting the reputation of your company? If so, you may have just cause. If not, it gets back to what I said earlier. You still have the option to dismiss that person on a without cause basis, but you're going to have to give them severance. The only caveat I'll add, we always tell people you can let somebody go at any time for almost any reason. And the almost there refers to any ground that is protected by human rights legislation. So things like religion and disability, sexual orientation, gender, etc. So those things are protected. You can't fire someone because of their religion. And in some jurisdictions in Canada, not all of them, political beliefs are also protected. So you can't fire them for their political beliefs or refuse to hire them for that matter. So that throws a little bit of a wrinkle into the analysis, but otherwise it's a very similar analysis to our hockey discussion from a few minutes ago.
Excellent. That was a good answer. So, Rob, let's see what the next question is from our audience. Am I allowed to track my employees' activity if they work from home? This is near and dear to my former private investigator heart. Go ahead, Stuart.
Yeah, at some point we've got to have you back and talk about some of your war stories. But yeah, this is a great, really timely question, and it follows from the fact that we've seen this great evolution to remote or hybrid work. And Some managers are not confident that their employees are working when they're supposed to be, and we get these questions all the time. And the simple answer is yes. The simple answer is that there are software and other tools out there that will allow you to do things like keystroke tracking or activity monitoring to see what your employees are up to. You can, first of all, as long as it's a company-owned device, that should go without saying, but I will say it anyways. You can't install that on your employees' devices. And you should advise the employee that you're doing it. Now, in Ontario, we have legislation that came into place last year, which specifically requires that employees be advised of any electronic monitoring. But even if you're in a jurisdiction that doesn't have that legislation, it's certainly advisable for a number of reasons to advise the employee. But as long as you do, then you are entitled to track their activity. Then you get to the next question about what can you do with your findings, which gets back to the whole dismissal with cause without cause discussion. But I don't know that we need to go there now. The simple answer is yes, you can, but you got to do it properly.
Excellent. All right, Rob, let's keep it rolling. What's our next question from the audience? I had to let a few employees go, and one of them is claiming I have to pay commissions during their notice period. Is that true?
I guess I'll say it again. It depends. But this is one of those areas where there are so many misconceptions out there. So that this gets back to how you calculate the value of someone's severance entitlement. So when you talk about someone being let go and getting severance, everyone talks about what'd you get? How many months? Was it 3 months, 6 months, 12 months, 24 months? But what we always tell people is in many cases, an equally, if not more important factor is what is a month worth? And so when you look at the common law, what the common law says is that an employee who's let go without cause is entitled to receive the compensation and the benefits that they would have received if they were allowed to work through the notice period. So that's not just base salary. It's salary, it's commissions, bonuses, incentive payments, medical, dental benefits, anything else they would have received. Unless there is something very clear in the contract or in the policy which says otherwise, and according to some recent case law, and that was very clearly pointed out to the employee. So there, again, I've commented on the fact that courts have been very employee friendly in the last couple of years. This is one evolution we've seen where the default really is you get all your compensation. And to address sort of the underlying question here, what about if you have a contract that says you only get this if you are actively employed on the date it's paid out? Because that's the most common language we see. You only get your bonus if you're actively employed. That's not going to cut it anymore. The courts have been very clear in saying that in and of itself, wording like that will not disentitle the employee to their bonuses, commissions, etc. And you can understand it to some degree. I mean, imagine a typical scenario where someone earns a bonus over the year 2023. So 2023 is over. They earned their bonus, but the company, of course, doesn't pay it on January 1st, 2024. They need some time to do their calculations, etc. So the payment's going to be made on March 15th. But they let this person go on March 12th. So now all of a sudden they're not actively employed on the day it's paid out. No court is going to enforce a policy which says you don't get it because you just were let go through no fault of your own. So the bottom line, to bring it back to the question about commissions, you're going to have to try to calculate what that person would have made during the notice period. And the typical way to do it is to take an average from the last couple of years and figure out what their earnings were. But it's always open to the parties to adduce new evidence. So you might, as an employer, you might say, yeah, he made $100,000 in commissions every year for the last 5 years, but this year our business was just tanking and he would have been lucky to make $20,000. And if you can prove that, then that's his entitlement. And the reverse is true too. He might say, yeah, my commissions were really low for many years, but this year I had all these deals in the works and I was set to have a record-breaking year. It comes down to the evidence of what the person would have made if they were allowed to work during the notice period.
Excellent. All right, Rob, we're going on a roll. Let's see what the next question is. Does a small company have to accommodate an employee who is physically unable to do their job?
Yeah, this is another question that comes up a lot and is near and dear to many business owners' hearts. We know that the vast majority of businesses in Canada and in the US for that matter are small businesses. And they're, so you're not talking about the IBMs and the Microsofts of the world. And this happens. And I literally, as recently as about 3 hours ago, I was working with an employer with a situation where, a small company, they've got someone who seems to have some physical and potentially mental health issues, and they're unable to work on a regular basis. They're often calling in sick at the last minute, or not even calling in sick, but just missing work. And the question is, do you have to accommodate? And the simple answer is yes. Human rights legislation requires that you accommodate to the point of undue hardship. So that's one of those nice legal terms that doesn't have a very specific definition. But the point is clear that there is an expectation that an employer will be able and will be expected to endure some hardship, right? You only get out of it if you get to the point of undue hardship. So a couple of points, and I'm mindful of time, so I don't want to go on too long here, but a couple of points. It's not as simple as an employer saying, oh, we can't afford that, it's going to be too expensive, or oh, we can't hire someone else, or we can't hire someone part-time, or we can't have them working part-time. You're going to have to produce evidence that will show either the cost that would be result from the accommodation, or the impact on the operation of the business, or something that makes it really not viable. And that's the test. It's not that you have to show it's impossible, but you've got to show it would really render the business not viable if you had to accommodate them. And that's a really, really high threshold. So in the vast majority of cases, you're going to have to accommodate. But the one thing I'll say, that I guess the good news for the employer side, you don't have to give the employee the accommodation they choose. So oftentimes you'll have an employee saying, here's a letter from my doctor, and my doctor says that you have to, give me the next 6 months off. Well, you're entitled to know what the limits are on that person's ability to do their job. And maybe they are able to work, but they can work with some modifications. And you as an employer might say, I'm not giving you 6 months off, but will allow you to work, 3 hours on, 3 hours off, or you're not going to be standing anymore. We're going to provide you with seating arrangements. You can accommodate them. And as long as the accommodation is reasonable, you've met your duty. It doesn't have to be the preferred form of accommodation that the employee suggests.
Well, that's great, Stuart. So I'm going to do something, I'm going to steal from you because I am the executive producer. It is true. Time does fly on this show, and we're way past that time. So at this point, I'm going to say thank you so much for giving me the opportunity to be in front of the camera, giving me the opportunity to ask you some questions, and more importantly, to hear your highly educated and thought out answers. I hope that our audiences, employers and employees alike, will learn from what they've heard today and what they will continue to hear on Fire Away.
Well, thank you so much, Mark. And just remember that highly educated comment next time we start debating hockey again. Kidding aside, thanks for doing this. I think it was great, and it was a great opportunity just to address some of the questions we've received and have a real life business owner ask them and follow up with some questions. So I really appreciate that. And now, before we sign off, I'll take my opportunity to fire away. So we just spent about half an hour in season 7, episode 3 of Fire Away answering your questions, and we probably could have spent a week. So one of the comments I always make is that I wish people would call their HR lawyers before they act instead of making assumptions. Now, that comment assumes that every business owner has an employment lawyer, which we all know is not true. So one thing I will say now is every business owner should have their team of strategic advisors. You probably have a corporate lawyer, you probably have an accountant, you should have an HR lawyer as well, and have that ongoing relationship. And then you should be reaching out, because as I often say, the reason our firm is so busy, and I don't want to complain about that, but the reason we're so busy is because people just don't treat their employment relationships as legal relationships. They don't take the time to think about how the law works before they act, or even think about the law at all, often until they get the nasty demand letter from their employee's lawyer. So we still, and sometimes people assume that they spoke to a lawyer once, so they know everything they need to. And I still see people using the employment contract templates I drafted for them 15 years ago. even though, as we talked about in season 7, episode 3 of Fire Away, we've seen dramatic changes to employment laws in many ways, including the treatment of employment contracts. So it's not just a one and done type of thing. You should have the ongoing relationship. And as we also talked about in that episode, and in probably many other episodes, without a good contract, your severance obligations can be massive. Take an extreme example, 24 months instead of 8 weeks of severance. So there are a lot of ways that you can be proactive, but we still get the calls after the fact. And when I ask someone, why didn't you call us before you let someone go? The typical answer is, well, we didn't want to incur the cost of emailing or calling our lawyer. So on that note, I want to mention one thing, which is, Rudner Law, we try to be a little bit different. We offer alternative billing solutions. And one thing we've been offering lately is subscription arrangements. So it's a fixed monthly fee. You have that cost certainty, but you're also not going to be charged for every email, every phone call, because we really want our clients to get the advice they need before they act. And we don't want you to be scared to call us. So bottom line is what I always say, and Mark said it during the episode earlier, if you think you need an employment lawyer, you probably do. So please reach out, and as I said earlier, develop that relationship with one. That's all the time we have for season 7, episode 3. So we're going to wrap that up. I want to thank everyone for tuning in. I want to thank Mark for joining me today. It was great to have you in front of the camera and have a really fun discussion, which I know could have gone on a lot longer. I want to thank Rob and Rebecca and Mark as well for making sure the show went as smoothly as always. Next episode is going to be on May 21st, and Brittany Taylor is going to be jumping back in the host seat. She'll be joined by my friend and a returning guest, Lauren McDonald. Should be a fantastic show. So thank you, everyone, for tuning in today.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.